Здравствуйте, дорогой господин Роман Аминов.
Добрый день.
Вы меня хорошо слышите?
Да, все нормально. У меня
Я
слышите?
хочу вас поприветствовать в нашей группе. У нас довольно солидное количество людей, и они, я уверен, с большим удовольствием послушают нашу беседу. First of all, we could speak English. I want to make sure that you will be comfortable. And if you can speak Russian and English, it would be better because most of our members are Russian-speaking people, but they are very well educated, and I believe that they will not have problems if you speak English too.
Understood.
And the reason why I ask you to become our guest, there are several reasons for that. And I believe that what you do is very crucial for people's well-being. And they, as far as I know, based on my practice, based on my experience, I believe that many people are not aware. They are not aware about many specifics of the legalities of their financial and estate planning, and that's why it's very valuable for them to listen to your presentation. So we are going to talk about different topics, but most important thing that these topics are related directly to their well-being. So first of all, I would like to introduce you to my audience. You, Roman Aminov, and you are in practice for more than how many years, Roman?
Over 12 years.
12 years. So can you please describe briefly what do you do, what exactly, why you selected this field? What is this interesting about?
Sure. So first, I want to say thank you to you for introducing me to your esteemed audience. Я постараюсь на русском, но мне было 4 года, когда приехал, немножко сложновато все вырезать правильно, но постараюсь.
That's okay.
You fulfill a very important role in educating the public in the importance of planning affairs properly so as to minimize stress and financial stress for families, for children who've lost parents. And so I want to commend you for your efforts in educating and bringing information to the masses. As far as why I decided to choose estate planning, it was simply a product of taking a course in trusts and estates and contrasting it with all the other courses that I took and realizing that this one particular area deals directly with the most sensitive issues of a person's life. We're talking about situations in which people are planning for their long-term care after having worked an entire lifetime and how to protect one's assets. We're talking about how to provide for one's children in a way where they can leave a legacy behind, but at the same time protect their children from unforeseen circumstances, divorce, lawsuits, disabilities. And I just took a personal affinity towards a course like that because unlike tax law or constitutional law, you weren't dealing in the abstract. You were dealing with concrete situations with people like you and I, and things that every one of us have to contend with. So after having taken one course in that, I decided to concentrate in that. I took an additional 4 courses in it, and then took about 80 hours in my first year being licensed of continuing education to more or less specialize in this field. So that's how I kind of came here.
Yeah, great. But this is great. What you do is also very essential, very, very beneficial to the public. But most people believe that the estate planning is only for the rich people. Do you agree with that?
No. Unfortunately, estate planning is a necessity for anybody who has anything, frankly, in their name, because the idea is that when you have what to leave behind, when you've worked for something, it's either you make a plan for yourself or the government has a backup plan for you. So there's a plan regardless. The only question is, are you going to be in control of that plan, understand that plan, and drive that plan? Or are you going to rely on the government and what they think may be best? And sometimes that's okay. But for most people, it requires even a conversation with an attorney or financial advisor just to understand what happens if I do nothing. That's my favorite question. What if you do nothing? And then let's explore that and let's see what the consequences are. So it's not just for the wealthy. The wealthy needs specific types of estate planning, tax planning, life insurance planning, but for estate taxes. But every one of us, anyone who's either has children or has even a little bit of assets, really should at least have a conversation about what happens if. So that's a very common misconception.
Yeah, that's right. You're right. Of course, for example, wealthy people need a specific approach with estate planning, and average people, average American needs a little bit different approach. So just because I am dealing with mostly regular people, and I would like to know what average person has to think in this particular area. What is the first step of estate planning for regular average person in this condition, in this situation? What we should do first?
Mhm. Well, it's going to come down to what stage of life are you in.
Okay.
So, are you single or married? Do you have children? How old are your children? What are your assets? But in its essence, estate planning is basically, if you boil it all down, what we're talking about is how to make sure that what you have goes to who you want it to go to in such a way where it doesn't take them a long time to get it. It doesn't affect their existing lifestyle in a negative way. It doesn't kick them off their government benefits if they're receiving it. It also encompasses what happens to the most important thing we have, our children. And if something were to happen to the parents, who's going to be in charge of taking care of our kids? Not only from a financial perspective, but from a practical, physical perspective, appointing guardians. So when you come to estate planning, you're basically looking at what are my assets, what are my goals, what are the things that I'm looking to protect, and who am I looking to protect? And it's hard to say in general what people should be considering, but I will say generally, anyone who has a child should always be conscious about what happens to that child if something happens to the parents. You go on vacation. I tell clients my number one say referral source, if it were to be, is people going on vacation. I'm going to Florida, me and my husband, we have children. I want to do a will just in case. Everyone considers, just in case when they go on vacation. It's important.
Yeah,
but
you just mentioned a very important word, a will. I know that so many people live without wills, properly designed wills, adequate wills. We call this interstate condition, right? Interstate condition legally. So I'm surprised that many people, especially people who came from different countries, they don't pay attention to that. Americans, they have experience of their parents. They dealt with these issues from the childhood, for example, right? Their grandparents also probably did something like that. But most people who came from, let's say, from former Soviet Union republics, they don't have such experience. So what do you usually say to a person? I know you deal with the Russian-speaking community also. What do you usually say to people or a person who is just 30 years old, single, or let's say just got married, he doesn't have a children or child? What would be the first advice you would give to this type of people?
So I would pose the question to them, you're working, you have a 401k, you have an apartment, you have a car, what do you envision for yourself in the future? And what do you envision if the worst case scenario ever happens? Are you comfortable with the fact that
I'm sorry to interrupt. What do you mean by saying worst case scenario? What is that?
What happens if you pass away? What happens if you become incapacitated? You're in a coma. Who's running your business? Who's paying your bills? Who's going to be receiving your assets? And if we're talking about people in their 30s, maybe they have parents in their 60s. And if they have parents in their 60s, it may not be unlikely that their parents are themselves planning their estates and looking to protect their assets from, let's say, Medicaid. Potentially, maybe they're on SSI or some government assistance. And maybe if a child passes away, their parents don't want to inherit the child's, 401k or their bank accounts or their apartment, because that's going to affect their public benefits and their estate planning. And so think about the people around you. If you're in that situation, you have not much to worry about. You're dead. Let's be honest. It's the people around you that you're really doing this for. It's a kindness to everyone around you. And that's one way to present this, so that people at least open up their eyes and say, okay, you know what is the answer? What does happen if I pass? Oh, I didn't know that if I'm single and I have no children and I have something my parents inherited. Well, I don't want my parents to inherit it. My dad's on SSI. How's that going to affect his benefits? Right. Okay, so let's plan around that. Maybe we set something up. We set up a will, and we say it doesn't go to my mom and dad, which is what happens in intestacy, like you mentioned. Right. Maybe I want it to go to my brother and sister who are working and fine. Right. So good. So we set up a will, and we say anything I have goes to my brother and sister. They can take care of mom and dad, and mom and dad's estate won't be affected in that particular example.
So basically, the approach should be that when we establish our livelihood, for example, if we build up our house or we want to build our family, the same way we have to build our system of protection, system of inheritance, system of financial security, system of the well-being for our children. Am I correct? So we always have to think the same way for something which is not touchable, right? Which is not seeable, like in a house or apartment or car, right?
Right.
So what would happen if a person dies without a will? What kind of circumstances will be complicating the situation for the people who will be behind?
So it depends on who his next of kin are. In the most common scenario, if a person passes, their next of kin will be either their spouse or their children or both. And in a situation like that, it depends how old the children are. But if you have minor children, for example, and you leave behind, let's say you have a business in your name or a house in your name, or even bank accounts or investments, and you pass away, your wife, your husband has to go through what's called the state administration process. It's a court process that they have to go to the judge and say, Your Honor, my husband or my wife died and they had something left in their name, and I'd like to be able to receive it. And by law, as a spouse, I'm entitled to get the first $50,000 and then half of everything else. And then
I'm sorry, Roman, first of $50,000 of liquid assets or any assets?
Of any assets. So if you want to be precise, the spouse gets the car up to $25,000. They get cash of up to $25,000. They get the household effects, and then whatever's left over. Let's say there's a $1 million Chase account. The spouse gets the first $50,000 from there, and then the $950 that's left over, the spouse gets half, and the kids split the other half, the $475, amongst the children.
Who's going to watch over this process? How is that going to happen technically?
So technically, the spouse will file a petition with the court, usually with an attorney, in the county in which the person resided, the decedent resided. That process with minor children becomes extra difficult, because when you have minors, you're basically saying these children are entitled to receive cash, but they're not old enough to actually receive anything legally.
Right.
So the court says, well, we can't have them receive any money. So now the court's going to say, we have to have their parent, if the parent is alive, become a legal guardian. The response I always get back is, well, I'm the parent. I'm already the legal guardian by default. And you're right. You have custody of the children, but you're not their legal guardian for finances.
Because there is no document indicating that, right?
Right, exactly. And there's no supervision.
Right.
And the court doesn't just say, well, okay, the parent's the guardian, give the parent the money. Because what if the parent remarries? What if the parent has debts? What if the parent spends the money improperly? Right. So the court says, not only do you have to become your husband's legal administrator, you have to become your children's legal guardian. So it's a two-step process. So the spouse has to collect the money, deposit half of it with the court until the children turn 18. And then the worst part of this is, it's in addition to all the legal process, is that if that parent wants to go to the court and say, Your Honor, my children, I have had this situation. My children go to public school, private school, or my children want to go on a vacation. I'd like to spend some of their money that's being held for them for their benefit. The court has discretion to say no. Why should the child's money be used for their schooling? You're the parent. Use
Right.
your own money. It's your responsibility. We're not going to use the children's money. That's for their benefit. And a parent is in a position where they're not able to fully utilize the child's money in the way that they think is best. And so that's one of the worst case scenario that I've seen it, where having something even as simple as a will can allow the children to receive the money, but not have the court approve every single transaction that has to occur.
That's what I wish to say. That what you just described, it's a very difficult process. First of all, attorneys have to be involved, right? The costs, legal costs, and the time also. Probably it'll take about 6 to 12 months to accomplish this. Am I correct?
Exactly right. Depending on which county, but in Queens County, it's about that time. In Brooklyn, I have cases lingering on for 1 to 2 years. And the costs are, you're looking at somewhere in the mid to high thousands. So anywhere, let's say between $5,000 to $8,000 or $9,000 with court costs.
Yeah. So in order to avoid these complications, the best advice you would give to anybody is to create a simple will or any will according to the wishes of your clients. Am I correct?
So yes, a will is, if you're going to have nothing but a will, it's better than nothing.
Right.
However, in other situations, and we can talk about it if you'd like, a little bit more proactive planning and setting up living trusts may be more appropriate.
This is my second question about living trust, right? Because I'm sorry to interrupt you, but before you go to that subject, I wish to talk to you about, let's say, I understand that will is a document which will govern the situation when somebody passes away, right? What will happen? What kind of documents somebody has to have in order to manage the situation when somebody becomes disabled, long-term disabled, or incapable to communicate, incapable to make a decision, financial decisions, business decisions, etc., etc. What will doesn't work in this situation, right? So what would be the solution?
So the will, like you correctly noted, is the document which only handles assets after a person's passed away, has no legal effect while they're alive. The document that you're referencing is called the durable power of attorney, which is a document which allows me to pick somebody I trust, and it could be my wife, it could be my parents, to say essentially, if something happens to me and I can't pay my bills, run my business, make my investments, I appoint you to be in charge as if you were me, and you can do anything I could have done for myself financially. So you can think of it as a will while you're alive. It's essentially the ability to handle finances while this person is alive, and that's this durable power of attorney, which in some situations, specifically for seniors who are leaving everything equally to their kids, is probably the most important document, even more important than a will, particularly for seniors. Because think of it like this: if you don't have a will and you're a senior, you have no minor children, let's say you have a house in your name, that house is going to, after you pass away, your spouse passes, that house is going to go to your kids automatically, even if you don't have a will. Through intestacy, the law decides that it goes to your kids. So not having a will, you'll end up in the same place more or less. But if you're a senior and all of a sudden you need long-term care, which happens so often, and now you have assets in your name that need to be shifted out, to be sheltered, to qualify you for long-term care, and you can't sign that document, you can't sign the deed or bank accounts, what are you going to do? How are you going to be able to qualify without having to go through a long, expensive, contentious, sometimes guardianship process where a judge will have to determine which one of your children, if any,
not you, judge.
A judge has to determine, and the judge will appoint a court evaluator. And there's going to be you have your own attorney representing you. We're talking, $10,000 plus in at least 6 months of time, just to be able to be in a position that you can pay your dad's bills and transfer your dad's assets so you can get your dad Medicaid.
Right. In this situation, very interesting information. I believe that people will be amazed about how they are not so close thinking about these situations, because people are fighting. I mean, not fighting. They want to establish their livelihoods and sustain their comfortable living. They don't think about this most of the time. But I wish to bring to your attention to the different situation in terms of what you just said. the will and the general power of attorney govern, these both documents govern the so to speak, a family relationship, right?
Right.
If something happened to the husband or wife and children and grandchildren and this and that, it's inside the family or grand family. What will
Right.
happen and what should people do when um, something happens to the partners
Mm.
in the
Unmarried.
business?
Oh,
So in the
right.
business,
Yeah.
so in the business, people, I have seen so many issues, so many instances in my career, and some people cannot even handle the situations because they
Mhm.
didn't prepare. They didn't prepare. No one told them that somebody has to think about this and prepare the documents for the situation, unforeseen situations like premature death, premature disability, etc., etc. So how people should handle this in the business?
Yeah, no, very important point. Um, you know, the question is when you go into business with somebody, do you want to go into business with their wife and children too? And that's really the question you're asking, right?
Right?
And so the answer for the most part is no. And it happens, two brothers go into business, they get along, the families get along. All of a sudden, one unfortunately passes prematurely, and now their spouse is charged with taking over their estate, managing their businesses, including their partnerships. And they may have a completely different point of view and maybe have no relevant experience to the business that they're taking over. And so, and I'm going to just preface this by a caveat that I'm not primarily a business attorney, although I have been involved in these matters. The advice that one should follow is any agreement you have, whether you have a shareholder agreement for a corporation or an operating agreement for a LLC,
Buy-sell agreement.
Buy-sell agreement. You always want to make sure that your agreement specifies what would happen in the event of someone's passing, someone's incapacity. Because a lot of times people just, okay, let's go into business, and they do it informally on a handshake, on an understanding, and it could work totally fine until it doesn't. And so even though your family, even though everyone gets along, it's always good to have in place succession planning,
Right.
continuity of management.
Continuation plan.
And
So basically, we have two documents, two sets of the situations and two sets of the documents, right? A specific will not govern anything related to the business, right? Will not. Will.
Well, the will does control what happens to your interest in a business. So if I own, an interest in a certain business, majority, minority, doesn't matter. I can dictate through my will what happens to my interest. Subject, however, to the terms of the original business agreement.
Right, right. For example, if you want to transfer your share of business to your wife in case of premature death, but the other partners must agree into this,
Yes.
right? To this transaction.
So
So
if I have
your will could say that, but it's not workable because other
Exactly.
partners will not agree. Am I correct or not?
Yeah. So you can, if I have a partnership and I have an interest and I put in my will that I give it to my spouse, and I have no operating agreement or no buy-sell, no shareholder, my spouse and the estate essentially take over and become partners in that business. However, if I had set up proper agreements in place with my partners, all my spouse will be able to do is take whatever interest the agreement provides for, and the agreement may provide for and should provide for, that the remaining partners have a right to value the business, get an appraisal, and buy out whatever interest I had at the time I passed. And a lot of times, and this is where someone like you can come in, a lot of times that funding comes from life insurance purchased by the partners,
Right.
either separately or through the business,
Oh, this is
so that the spouse, or rather the partners remaining in the business don't have to come out of pocket and try to find liquidity. They have the liquidity automatically coming through a life insurance policy, for example, which will fund the buyout, give the spouse what they're entitled to, and let the business continue operating so that you're not, wondering why you didn't plan ahead and you're dealing with someone who has no idea.
That doesn't create a disaster for the business as well.
I've seen it with siblings, with real estate. A lot of times in the jewelry industry, people have questions. Children step in when a father passes away. You're better off preparing in advance, even if everything's fine today, and considering not only planning. We're lawyers; we can do the structure, but people like you are the ones who actually provide the meat behind the bones. how do you fund it? I could put a cost together. You do a buyout, you appraise it, you take, averages of appraisals, and you come to a number. Okay, but if I'm cash poor and I have to buy out someone for $1 million within 90 days, it's useless if I don't have the funds. They should also consider second step. Do I have the liquidity, or will I have the liquidity? And if not, what are my options to have that liquidity?
Great. Let's talk about the living trust. I know that you dealing with a lot of situations when people need living trust. Can you describe us, members, what is this about? What kind of legal document is this? What it gives to people? What the benefits of living trust? When the living trust is needed? When it doesn't need it?
Sure. Yeah, it's a very important topic. And it's one that's very abstract, because people hear trust, you're not sure where to put it in. It's not a business. It's not a will. It's like a combination of both. And honestly, it took me at least one entire semester in law school just to be able to fully understand what's being talked about. But I just want to give an analogy of what a trust is. I'm going to say like this, Mr. Yusupov, Dr. Yusupov, I like you, I trust you, and I want you to be the guardian of my cell phone, okay? My cell phone.
Right.
This represents everything I own in the world, okay? I'm going to give it to you because in case something happens to me, I want you to be able to take this phone and allow my family to use it however they want, my wife, my children. And then when my children turn 18, I'd like for you to give them this phone for them to keep, okay? So if you say, okay, Roman, no problem, I understand. If something happens to you, I'll be in charge of it. I'll let them use it to make phone calls and then give it to them when they turn the appropriate age, right? And if you say, okay, and I say, okay, and we sign a contract, that becomes a trust agreement. It sounds silly. Why would I ever want to do that? Well, what if I say like this? I tell my brother, hey, Jonathan, my brother, I have a house and I would like to be able to live there and use it and occupy it and everything else. But if something happens to me, I want you to be able to hold that house for my children and let them live there for the rest of their childhood until the youngest turns 18. And then when my youngest child turns 18, I'd like for you to be able to sell that house and give them the proceeds equally, or to put the house in both of their names so they can own it together, right? What that just did right there is made it so that if something happens to me, I don't have to worry about a probate or a court or a judge, because what I did is I transferred that interest of my house or my assets into this trust agreement, this contract that I set up with my brother. And when I pass away, the owner of that house is not me anymore. The owner of that house is this trust.
Right.
And so when I die, the trust provides for what happens automatically. And it provides that my brother takes over the next day or the same day. And he can then deal with it however I set out. And so what that just did is it saved me about a year of court, saved me about, let's say, $8,000-9,000 in legal fees. And it made my process a lot quicker and easier for my passing. And a house is simple, okay? No one's really worried about a house because it just sits there. They live there regardless. But what if I have an operating business? What if I have a stock portfolio that needs to be managed maybe more actively? What if I have, a rental property with tenants in there and there's nobody to collect the rent for a year because the executor hasn't yet been appointed? So what this trust does, what this agreement does, essentially allows immediate access to my assets when I pass, and thereby avoiding the court process and allowing the continuity of management.
I have a question, Roman. So in order to make sure that everybody understands what we're talking about, if we compare will and a living trust, it wouldn't be better for me to, in order to have two separate documents or agreements, so to speak, like will and, will is not an agreement, but it's my wish written on the piece of paper, right?
Exactly.
So agreement is the trust. But instead of putting my wish into the trust, this is your wish, right? You wish your house to be held on this trust and in the future disposed according to your wishes, right?
Right.
All right. So if I would do this through my will, what will happen? What would be the difference?
So the will can do the same thing that a trust can do eventually, but the will has to be probated. Like we spoke about the administration process.
Right.
If I didn't have a will, if I had a will, it still has to go through a court process. And people are surprised by that. They say I get a few phone calls a day at least where people say, oh, I didn't know that I have to probate my mom's will after she died. I just thought she had a piece of paper and it's valid. And I say, no, unfortunately, the judge has to look at the will, make sure it's a valid will, and then anyone affected by the will, so all the other children, perhaps, depending on the family structure, they all have to sign off on the will too. They have to say, okay, I'm comfortable with this, because what if it's a forgery? What if it's a fraud?
Yeah.
And
What
so,
makes, I'm sorry, very
Sure,
quick
sure.
question. What makes the will invalid
so
or
I've had
invalid?
I've had a few scenarios where people come forward with wills that, let's say, don't have two witnesses on them, so that's not valid. I had a will where they were witnesses, but the witnesses apparently never saw the person sign, so that makes it invalid. Sometimes people contest wills because they say, look, my dad was, 97 and senile for 3 years. He had dementia for 3 years before this will was even signed. How could he have signed this will and had capacity? He had no idea what he was doing. That's an argument people can bring. People say sometimes, oh, my brother and sister, they influenced my father. They forced him. He didn't have the ability to defend himself. That's another grounds for objection. So there's different grounds
So
one can object to.
will must go through the probation.
Correct. People
In
think, oh, I'll
state of
set up
New
a
York
will.
or any place? In state
It's a
of
good
New York?
question. I don't know about other state laws in detail. As far as I know, it's in every state, but certainly in the state of New York where I'm licensed.
Okay.
And yeah, so
One more question. Mhm.
yeah, no, I'm just saying a will is not a document. People often think, oh, I'll just set up a will, it'll avoid probate. The irony is that the only way you get into probate is if you have a will. If you don't have a will, you go through administration. So it's a very
Courts are
common
busy
misconception.
as well, right? Courts are
Oh,
busy. You cannot do
Courts
this
are
easily, right?
extremely busy. Like I said, Brooklyn sometimes takes 6 months to a year and longer.
Wow. I have a question about the tax consequences and the differentiation between the will and the living trust. Let's say if you transfer your property by mean of will or by mean of living trust,
Mhm.
what would be the tax consequences in the situation when the disposition of the property brings to the person who is receiving the property capital gain in case of sale, or let's say disposition, or if it's stocks or whatever security.
So I'm not going to talk about all trusts because they could be very, very varied. Trusts are like people. There's a different variation. But in general, what you're looking for is the ability to step up the basis of any acquired property.
Cost basis.
Cost basis. So, for example, if I bought a house for $500,000, and then when I die, it's worth $1 million, there's $500,000 in gain that I'd like to be able to eliminate completely when my children go to sell that property. I want them to inherit the property as if they bought it for whatever it's worth when I die. That's called the step up in basis.
Right.
So to preserve that, I need to be able to have control over the estate. And that's accomplished in both the will and the trust, because in either scenario, properly drafted trust will keep the estate in my name. So I'm taxed on it, but I'm not really taxed because in New York, I have $6 million that I can leave in assets without being taxed.
Exclusion.
It's the estate tax exemption.
Exemption.
Federally, I have this year about 12 million, although it's going to go down to around 6 or 7 in 2026. But I have enough to play with where I may not be concerned about taxes for most people. And then I'm more concerned about not having my family pay capital gains tax on all that gain that accumulated. So what I see a lot of times in our communities is that people say, look, I have a house or this and that. I want to put in my kids' names. Let me just transfer to my kids while I'm alive. I want to get Medicaid. I want to, whatever. And I often have to explain to them this concept. And I say, if you transfer it to them, they take that house at whatever you purchased it for.
Right.
And it never gets stepped up when you pass away.
Right.
Right. So if they, on top of other negative tax consequences, if they ever sell that house, they pay a lot more in capital gains tax.
Right.
However, if you hold on to it, you put it in a trust, even if you leave it in a will, when they inherit it, all those capital gains are wiped out. So I would say the biggest, piece of advice in our community when it comes to transferring properties, speak to an attorney, but don't do it directly into the individual's name if you have appreciated property. That includes stocks and that includes other investments, but particularly homes, I see it.
What about the proper real estate properties specifically, which are held in the trust? Most of them are, as far as I've seen in my clients, they have a lot of real estate which they hold hold in the irrevocable trusts. What will happen in this situation? Are they going to benefit from this step up basis?
So it depends. Not all irrevocable trusts are grantor trusts, and not all irrevocable trusts have the estate, the corpus of the trust, the stuff inside of the trust. Not all of them have it includable in the original person's estate.
Mhm.
The trusts we draft are more geared for people who are applying for Medicaid and long-term
Right.
care, and we don't have a taxable concern for most of these people. And so the way we draft our trust is it is includable in their estate. They do have certain rights, which the government says, aha, you have all these rights. We're going to count it as your asset when you pass away, which I don't care because I'm not being taxed on it. But what I do care about is because it's included in their estate, their children get that step up in basis. But there are some types of trusts, these irrevocable trusts that are non-grantor trusts, where the person does not retain control, where it's not included in their estate.
Right.
And those types of trusts do not get a step up in basis in the underlying property. So you have to be very careful when you're planning that you're weighing the benefits of estate tax savings versus the cost of capital gains expenses.
Right. Roman, many people do not know what exactly is included into the estate. What part of your assets are included into the estate, what are not? Can you describe?
Sure. So estate could be defined differently in different situations. So, for example, if I have a bank account with a beneficiary on it, and I have a house just with my name on it, for the court purpose, my estate is just the house because the bank account automatically goes to my beneficiary. It's not part of my estate for, let's say, probate purposes.
The same is pension plan, for example, also.
Pension,
right?
yeah, correct.
Pension
If you have a
plans for the one
beneficiary,
play, yeah.
so
Because
for
it's
probate
designated.
purposes, I'm sorry?
You have a designated beneficiary.
Correct. So in the context of court and probate, that's not part of my estate. But if you're talking about in the context of, let's say, tax planning and estate taxes, things like pension plans, houses, bank accounts, even if they all have beneficiaries, are part of my estate. In addition, any life insurance policies I have, the death benefit and the cash benefit are also part of my estate, which leads to a very interesting scenario where a person can live their life and have under the estate tax limit. And let's say they're worth $4 million. So if they pass away, they'll have their family has no estate tax to pay. But that same person may have a life insurance policy of $3 million. And if they pass and life insurance is in effect, their estate now becomes a $7 million estate. And all of a sudden you have tax that your family has to pay that you otherwise could have saved. So the estate for tax.
I'm sorry. What is the solution in this scenario?
So the solution, depending on their wishes, but specifically for life insurance policies, which could be rather large, and for good reason. You have, children's college tuitions and, private school and everything else. And by the way, you didn't ask me to say this, and I'm not saying this because you happen to sell life insurance, but it's so important to have sufficient coverage when you're planning your estate. And I tell this to my friends, and I don't deal in insurance, but I always tell my friends, hey guys, like you have children, they go to private school, you have 4, 5, 6 children. You don't want to end up on a GoFundMe, if God forbid you lose a spouse, to pay for their tuition. Make sure you calculate how much costs will be, private school, college, maybe a wedding and beyond for each child, inflation adjusted, and make sure you buy sufficient insurance. $3 million is not too high of an amount. That should be a starting point. But the point is, once you have that plan and you have your insurance purchased, and let's say you have other assets, it may not be a bad idea to consider taking your life insurance and making sure that it's out of your estate, because it doesn't necessarily appreciate in value. There's no capital gains tax that you need to step up for. Take it out of your estate. Set up that irrevocable trust that you have no control.
Life insurance trust.
Irrevocable life insurance trust.
By the way, do you do that? I mean, do you handle this type of?
So yeah, irrevocable life insurance trust, we have had opportunity to handle. It's not something we do on a constant basis because we don't do much high net worth planning. I'm like you, we deal more with the middle class.
Right.
But if clients have questions, we'll address those questions and can handle that portion. But it's just important to you've raised a good question to consider what is in your estate, pull everything together, things you may not even have thought of, and then break it all down. And some things are a deduction. For example, you have a $5 million property with a $3 million mortgage. You have a $2 million estate at that point, because we're looking at net assets.
Right now, many people consider one way to escape state estate taxation to move to the states which do not have state taxes.
Right.
One of them is Florida.
Right.
So how do you handle the situation when you have client who has a dual state citizenship, so to speak, right? New York, Florida. How New York? I know that New York's law is very tough, and they chase their previous residents all over the place, even all over the world.
Yeah.
Because they need their money, right?
Oh yeah.
So how estate attorneys handle this situation when you have properties in different states and you have dual residency? What is how it's complicated?
Yeah, no, so that's a very complicated factor. So much so that there's specialized tax attorneys who deal specifically with these questions and the almost certain audit that comes with one claiming that they're no longer a resident. I heard someone say it's 100% audit rate for these people. And I've had friends who've done that for tax purposes, high net worth individuals who are looking to save not only estate tax, but also income tax. So obviously there's factors they look to, how much time do you spend in Florida versus New York? Where do you vote? Where do your kids go to school? Where do you own residential properties? Where do you generate majority of your income? So obviously you have to be in compliance with that, and that's beyond my expertise. But when it comes to basic planning, when they have, let's say, real estate in New York, or mostly real estate, and they've established with their specific tax counsel that yes, based on your factors, you're a Florida resident, but I still have, real estate in New York. How do you square that? Thankfully, New York only taxes the real estate that you have here in New York, and doesn't extend its reach to property elsewhere, assuming you're established as a valid resident in the other state. Right. The same works in the reverse. So if you are a New York resident and you happen to have real estate in Florida or anywhere else, they don't look to your Florida real estate as part of your New York estate. Mm-hmm. They keep that separate, but they do look at all of your assets. So if you have a bank account, you have, say, an LLC interest you own, and the LLC is maybe based in Florida, they still count that as a New York asset because that's personal property. Right. But for real property, it's excluded from your New York estate tax.
Yes. Right now, many people in this country are concerned about the future of long-term care. So I know that many people do not have long-term care protection, and most of them most probably will not be eligible for the state programs. And this is very, very vulnerable issue. And I know that some practitioners, attorneys, financial planners provide a lot of services advising their clients to prepare themselves for the future events like that. So I would like to know if this type of issues have a part in your practice. What do you do? What kind of work do you do for your clients? Can you please describe the details?
No, that's a very big factor, because you can spend your whole life working, and then the last 5 or 10 years of your life, you can pretty much wipe it all out, even if you've made a lot of money. So long-term care is really a big deal.
By the way, for our audience, long-term care, can you please be specific? What does it mean?
Of course. Long-term care, we generally define as care that you need on a consistent basis for assistance with activities of daily living, cooking, cleaning, bathing, going to the doctor. And so we're talking about a home attendant, practically, coming to your home full-time or, on an hourly basis, or in a worst-case scenario, nursing home care, in which no care could really be provided at home safely. And despite everyone's, best efforts, you're better off being in a nursing home where they have the skilled nurses to provide the care you need. So practically home attendant or nursing home care.
How about adult care living also?
Right, so assisted living
Assisted
facility,
living.
where you're basically independent, except you have support staff around you and you have programs geared for seniors. That's more of an intermediate step. The government program is a little bit more limited in that regard, but yes, we do certainly help clients qualify for those limited programs to the extent that they exist. One people may know about, if they're in the Queens area, is called Boulevard out, by the way, by Casino Boulevard. That's also a facility which can provide assisted living, but for the most part, assisted living is private pay, not really government subsidized.
Mhm.
But when you come to long-term care, whether that be in the home or in a facility or an intermediate facility like that, for the most part, you're looking at one of three options. It's either four options. You're getting home care provided by your family, and not really government assisted, which a lot of people, I think most people would prefer. Sometimes the opportunity is just not there. Children are far away, they're not available, whatever the case may be. And so then you're looking to either private pay if you have the resources. We're talking about, let's say $25 an hour, 8 hours a day, 5 days a week. Depending on your resources, that could be a significant amount. You have long-term care insurance, which I think the stat I saw last was like, I don't know, 5 to 7% of people have, but
it's very difficult to obtain right now. Many insurance companies left this market. Many.
Yeah, it was costing them too much.
Yeah.
People were utilizing it. They didn't, budget it appropriately. So that's kind of rare. Or for the most part, if people are not getting care in the home from their family, they're going to be applying for Medicaid. And like you said, most people are not going to qualify for it. Not without effort, at least.
Yeah.
Not without essentially making themselves poor on purpose. Because if you are applying for Medicaid, which is the long-term care provider, not Medicare, but Medicaid.
Medicaid, state program.
Yeah, Medicaid, yes, it's a state federal program, administered by the states, but partially funded and regulated by the federal government. And that's why, by the way, each state has a different version of Medicaid.
Right.
So whatever I'm saying now will apply to New York, but it'll be completely different in Florida and even in New Jersey.
And the New York State's program is one of the best ones, right? In terms of protection. Am I correct?
Yeah, you're 100% right. I guess part of the downside of paying so much in taxes when you're working is that it's going to fund people who are basically making themselves poor to qualify. So New York is very generous in that regard. New York currently, at least until March of next year, allows you to basically be a millionaire one day and transfer your assets out the next day. And the following month, you can qualify for Medicaid home attendant services without, and I've had situations where I've had literally $5 million of real estate transferred by people who then within a few months each have had 24-hour care in the home. They're elderly people provided for by the government. One of them is still alive getting the care while their son enjoys a $5 million estate.
So how did you transfer that to son or to the trust?
So in that particular case, I strongly advised them to transfer it into the trust. I told them about the tax benefits and everything else. For whatever reason, they said, no, we want to transfer directly into his name. And it's very rare that we do that. But in that particular case, we did directly into the son's name. So he owns the property and his parents are getting the care. And, that's just the New York State program. Other states wouldn't let that fly as easily. Most states, they have a 5-year look back when it comes to home attendant care. New York will have a 2.5-year look back starting in March of next year. Hopefully, maybe theoretically, whatever. They may push that out a little further. They've already pushed that out a bunch of times before. But for the most part, it's very easy to qualify for home attendant care, at least under current law. And what attorneys like myself do is if people don't have long-term care provided for, and they do have assets, we set up these certain types of irrevocable trusts that are not really geared for estate tax savings. They're geared for preserving the client's right to live in the house, maybe collect the rent if it's coming in from the tenants, to be able to change their beneficiaries if they wish, have some control over the property, but from a legal perspective, not be the owners of that property anymore. So they give it away to be held for in trust by their children for the most part. They keep the same tax benefits. They keep the real estate tax exemptions low, the STAR exemption, seniors, citizen, homeowner exemptions. Those all stay the same. But for Medicaid purposes, they tell the government, wait, it's not mine anymore. My child controls it now. And they get the care they need. And upon their passing, the house avoids probate and goes automatically to whoever they've listed as their beneficiaries.
who is not going to be qualified no matter what you will do for him? Are there
That's
any
great.
exclusions?
Yeah, so right, if I can qualify you with $5 million, why couldn't I qualify? So I'll tell you, people with significant, let's say pensions or retirement plans, income streams. In my practice, a lot of times it's teachers, old school teachers with really good pensions that are guaranteed like 7% a year or something, no matter what, and they've accumulated millions of dollars in there, and they're in retirement. They're going to be making, $15,000 a month, let's say, Social Security, pension, and sometimes even more, husband and wife, and people like that. Even if you're going to try to transfer those, pension plans out, or let's say retirement plans, you're going to pay all these taxes up front. It's because you have to liquidate all that and pay all the tax. And sometimes pension plans, you can't liquidate a pension plan. It's just a recurring income stream. And if your income is high enough, it's almost impossible to qualify for Medicaid, because let's say you're making $15,000 a month. If you go into a nursing home which charging you $12 or $13 or $15,000 a month, they're going to take all your income first before they pay for anything. So at that point, you're just private paying.
One very important issue I want to discuss today, probably we'll just finish with that, because I don't want our members to be bored, right? The rule of state reclaiming back of your assets if something is not correctly drafted by the attorneys. How does it work?
Wow, thank you so much for raising that question. I'll give you the overview, and then we can talk about specifics. The overview is that if you're on Medicaid and you received Medicaid over the age of 55, or if you're on nursing home Medicaid at any age, and you have a property in your name, usually it's a co-op, a condo, or a house. And the reason I say that is because if you're receiving Medicaid, you probably don't have much more than that, because they limit you as far as assets go. And right now, you could have $27,000 in assets. But let's say you have a house, you live in it, you get Medicaid, home attendant services, and then you pass away. And you set up a will, or you don't set up a will, either way, and you provide that, it goes to my children when I pass away. Your children have to go through.
Before you go further, I'm sorry to interrupt. I'm sorry, because very important,
No,
so
please.
in this situation, just you describing, we don't have anything planned before. We didn't plan anything for this situation, and we don't have any trust, anything like that, right? Just pure will.
Let's say you did plan with a will. At least you did that.
Only
Okay.
will.
Will or no will, but
Okay.
no other planning other than just putting your wishes. What happens after you pass? So in a situation like that, as we discussed, your family has to go through a court process, either probate if there's a will, or administration if there's no will. So on its face, it's not such a big deal. If you're an adult, you don't have any minor children, you're fine, because the probate will take, let's say, 6 months. It'll cost a few $1,000s, not a big deal. Your family will wait to get the money. Okay, fine. But what people don't know is that Medicaid has not only a right, but an obligation to file a claim against the estate of the parent who got Medicaid, legally got Medicaid.
How they will find out?
So what happens is, once you file something in court, it becomes a public record.
Okay.
And Medicaid has workers who go through the public record, link up people who've received Medicaid with the public record of people who filed for estates, either probate or estate administration. And then they send out letters to the family and to the attorney. And I have maybe 15 or 20 of these letters saying, I'm sorry to hear about the loss of your parent. However, we need to recover against their estate because they received from this day to this day Medicaid benefits in the amount of, and they list the amount. And now, before you can do anything, before you can receive those proceeds from your parent, you have to first pay that bill. It's like a creditor of the estate. And sometimes that bill can be as large as the estate, and sometimes even more. And essentially, they can render the entire estate insolvent.
Wow.
And the family can get nothing.
Wow.
Yeah. And when it has happened to me, when people have come to me already having done this and started the probate, I tell them right away, like, listen, you're going to have an issue here coming down, in the next. And I had this like last week, a guy came, didn't know. And in that case, his dad had a co-op and his dad needed Medicaid. Mm-hmm. Maybe nobody told him, maybe they didn't care, but the co-op didn't allow for trust. He actually came to me while dad was alive. and he says, look, I want to set up a trust. We tried to, the co-op did not allow it. So what are you going to do? The dad, he needs the care, he needs the care. He got the care.
Mhm.
But now we're doing probate, and I told him it's going to come down. Not, I don't know when they're going to send us a letter. So okay, we deal with it how we can.
Mm.
And the shock that people have is, but why? They were legally entitled to Medicaid.
Right.
Why is the government coming after me? And I said, look, just because you're eligible for it, it doesn't mean that you're protected on the back end. But here's the beauty of it. And again, speaking of New York is very generous in this regard.
Right.
Because the federal government said generally states have the opportunity to decide how they enforce this recovery right.
Mm.
They can either go after all estate assets. We spoke about estate, right?
Right.
So
Right.
assets that go through probate and assets that don't go through probate.
Right.
Or they can choose to only go after the probate assets.
So,
And New York
for example,
chose-
for 401k will not be touched, for example.
Correct. And by the way, if you do have Medicaid and you have a 401k and it's giving you income, which you're allowed to have, make sure you have a beneficiary listed on that.
Right.
If you don't have a beneficiary, it goes through probate. And in New York says we can only go after probate assets. So
Right.
it's so easy to assuming your co-op allows it, but if you don't have a co-op, a condo, a house, it's so easy to avoid probate.
Right.
All you have to do is know about it and plan for it. And you plan for it again by doing a trust for the most part. And that's honestly the biggest piece of advice for people who ever want to qualify for Medicaid is be careful of Medicaid estate recovery. And thank you for mentioning it.
Yeah. Unbelievable. I'm so happy that we have such a beautiful, interesting conversation. Roman, thank you so much. I believe that we have to continue.
I'm
Because
here.
I know that my people will be asking you questions. I just want to make sure that they are comfortable to receive enough information at certain period of time. So let's
Sure.
finish for today. And I would like to know if our members want to contact you,
Mhm.
how should they do that?
Sure.
Can you?
I appreciate the opportunity to speak to your members. I understand they're a well-educated, well-informed group, not in no small part thanks to you. As far as reaching out to me, I offer a free consultation, free phone consultation, so they can call me. My number should be easy to remember. It's 347 Roman 85. So
347 Roman 85.
So yeah, so 347-766-2685. They can also email me, but phone is going to be the best way to approach it. I will schedule a time to speak. Every situation is different. We'll discuss it, no obligation. And,
Would you mind
hopefully you
if
guys have
I place your information on our group's dashboard?
Of course, my pleasure. Yeah.
So I promise to our members that we will arrange another meeting with you, Roman.
I appreciate
Thank
it.
you so much. I really
Thank
appreciate
you for
it.
having me.
And I got a lot of new information. Thank you.
I appreciate the opportunity to speak with you. Thank you for the audience, and I look forward to being in touch.
Bye-bye.
Bye-bye.